Kim Straker, and I want to welcome you to our HR Forum event today. We have 3 distinct hot topics that we'll be covering. I'd like to introduce you to my 3 colleagues, Christy Iacopetta, Lotus Cannon, and Michelle Shamulian, who will be leading our discussion today. I'll be moderating. We have a PowerPoint that we've prepared to help you follow along during our discussion, and we'll be emailing you a copy of the PowerPoint after the event, probably sometime tomorrow. Christy is going to begin our discussion today by covering legal updates on pay transparency, which affect companies operating in many different states. She'll also cover the details of the New York City law, which becomes effective on May 15th. Next, Lotus will cover website accessibility under ADA Title III. This is an area of the law where we've seen a huge uptick in lawsuits. In the past 5 years, the number of lawsuits filed against companies alleging that their websites are not accessible has more than tripled. And in the last year alone, we've seen a 14% increase. Last, today, Michelle will discuss the recent suite of New York legislation covering sexual harassment and retaliation. She'll advise you on the laws that you have to comply with, as well as the bills that may become law very soon. If you have any questions during these 3 presentations, please put them in the chat box. I'll be monitoring the chat box, and we will try to address your questions at the end of each presentation. If we can't get to all of your questions during our designated hour, we've also set aside additional time for questions in a separate breakout room that you can opt into joining at the conclusion of our presentation. You'll see a prompt come up on your screen, and you can select which room you'd like to enter based on the topic. And in each room, you'll be able to ask your questions live to Christy, Lotus, or Michelle. If you're unable to join us in a breakout room, you can also feel free to reach out to any one of us by email or phone with any of your questions. Also, we wanted to let you know that we're recording this event so that we can send the recording out to those clients who aren't able to attend today. I will be announcing the CLE code later for those of you who want CLE credit. And with that, I'm going to turn it over to Christy to begin our HR Forum event today. Thanks.
Great, thanks, Kim. So a hot topic for the last few years has been pay equity and closing the pay gap. And it continues to be a hot topic. And one major trend we're seeing right now is a push for greater pay transparency. Fortunately for employees, a number of states and local jurisdictions have laws on the books requiring employers to be more transparent about their pay ranges. And the theory behind that is these requirements would make employees and applicants more knowledgeable about their pay, make them more likely to ensure that they're being paid fairly, and make companies more likely to focus on their pay practices, all of which will help hopefully eventually close the pay gap. Unfortunately for employers, this patchwork of state and local laws can become an administrative nightmare. Not only do multi-state employers have to track which states have requirements and which ones don't, but they also have to be aware that each state's requirements vary in terms of to whom the disclosures must be made, what type of event will trigger the disclosure, and what information needs to be disclosed. So the jurisdictions that currently have pay transparency laws sort of fall into 3 main buckets. The first is those that require disclosure upon an applicant or an employee's reasonable request. The second is those that require proactive disclosure at a specific point in the hiring process. And the third is those that require disclosure on job postings. And to make this even more difficult, some states even have different requirements depending upon whether you're talking about a current employee or external applicants. So we've provided a good amount of detail here in the slides, but I need a whole separate webinar to get through all the details. So I'll just go through high level and then we'll take a deep dive into New York City's new law. Next slide, please. So the first bucket here is jurisdictions that require disclosure upon request of an applicant or an employee. So for example, in California, the pay scale, meaning a salary or hourly wage range, must be disclosed upon reasonable request made after an applicant has completed an initial interview. But in Maryland, employers must disclose the wage range, which is undefined, upon reasonable request, and you'll notice there are no specific timing requirements of that request. And then in Cincinnati and Toledo, the pay scale, which is also undefined, must be disclosed upon reasonable request after a conditional offer of employment. And lastly, in Washington State, you have to disclose minimum wage or salary to applicants and wage scale or salary range to employees, both upon reasonable request after an initial offer. So I made it sound easy by saying that all of these laws fall within 3 general buckets, but you can probably already see just within this first bucket that each state requires something a little bit different. So your recruiters and hiring managers will need to be trained on whether they're required to provide pay information when an applicant requests it. If so, what specific pay information needs to be disclosed, and when in the hiring process it must be disclosed. So say you have operations in Maryland, Toledo, and some other state that does not require pay transparency. If an applicant in Toledo asks for the pay scale during an initial phone screen, your recruiters need to understand that that disclosure is not required in Toledo before an offer is made. Contrast that with Maryland, where an employer can ask at any point for that information. And to make this all a bit more confusing, California and Washington State have pending legislation that may change the requirements that you see here on the screen. And it may actually require disclosure in job postings. So you can see how this is very difficult to track. It's constantly changing. New states and new jurisdictions are constantly adding laws as we go. And this is just the first bucket. So next slide, please. The next bucket here includes states that require disclosure even in the absence of a request. So in California, for applicants, you have to disclose the wage range upon the earliest of the applicant's request or prior to or at the time of an offer of compensation. For employees, it's upon hire, a change in the employee's position, or the employee's first request. Then in Nevada, for applicants, you have to disclose a wage or salary range or rate upon completion of an interview. For employees, you have to disclose when the employee has applied to a promotion or transfer, completed an interview, or has been offered the position and has requested the wage range. Similarly, Rhode Island, as you can see here, breaks up and differentiates between whether an applicant or an employee is requesting that information. Next slide, please. So the last bucket here, these are states that require pay disclosures on the job postings. And this is definitely a bucket that I can see growing probably quicker than some of the other buckets we went through. So Colorado is the first state to adopt this type of requirement, and it's pretty far reaching. For roles that will be based in Colorado or remote roles that could be performed in Colorado, employers must include in job postings the hourly rate or salary compensation or range thereof that the employer is offering for the position, a general description of any bonuses or other types of compensation that they'll offer, and a general description of all employment benefits offered for the position. Jersey City just joined last week when the City Municipal Council unanimously adopted a requirement for Jersey City employers to disclose a minimum and maximum salary and or hourly wage and benefits in any print or digital media circulating within the city that provides a notice of employment opportunity. So we're confirming with the city still, but we believe this requirement will take effect on April 12th. Next slide, please. So last but not least, we'll just take a deeper dive into the new New York City law. So New York City requires, effective May 15th, 2022, that job postings include the minimum and maximum salary for the position. So New York City has been very active over the last couple of days or a couple of weeks or so. And they issued a fact sheet that answered some of the questions that we all had about the new law. But they also proposed an amendment already to the new law that may make some changes. So I'll go through what's currently on the books, and then I'll go through quickly how these amendments may change some of this. So currently, effective May 15th, it will be an unlawful discriminatory practice for an employer, employment agency, or employee to advertise a job, promotion, or transfer opportunity without including the minimum and maximum salary range for the position in the advertisement. And this requirement applies to employers with 4 or more employees, at least one of whom is in New York City or working in New York City. It does not apply to temporary help firms seeking applicants to join their applicant pool, but it would apply to employers who hire temps, assuming that they advertise for the position. And that actually brings up a good point. So nothing in this law requires employers to post their jobs. But if they do, they have to include that minimum and maximum salary range. And the minimum maximum salary is defined as the lowest and the highest salary the employer in good faith at the time of the posting believes that it would pay for the job. It does not include any other forms of compensation or benefits, although an employer may include that information if it chooses to. The ranges cannot be open-ended. So for example, you can't say for this position, I would pay $100,000 and up. That would not satisfy this requirement. If there is a set rate for the position and the employer does not have any flexibility, you could, for example, say $20 per hour. The good faith at the time of the posting was a welcome addition for some employers. So if you had say an accountant position and you posted that position with a maximum pay of $100,000, because at the time of the posting, you believe that in good faith that was the most you would pay for that position. But then a CFO that decided they want to be an accountant now decided to apply for the position and said that they would accept that accountant position for $110,000. There is nothing in this law that would prohibit you from hiring that CFO, now become accountant, for $110,000, despite the fact that you had a maximum of $100,000 in your posting, as long as you reasonably believed in good faith at the time of your posting that $100,000 was the most that you would pay. Okay, so when does the pay information need to be included? That's when you're advertising for a job, a promotion, or a transfer opportunity. And an advertisement is defined as a written description of an available job, promotion, or transfer opportunity that is publicized to a pool of potential applicants, regardless of the medium in which it is disseminated. So probably the most frequently asked question that we get about whether this applies is whether it applies to postings for remote work. So currently, yes, it applies when advertising for positions that can or will be performed in whole or in part in New York City. But that is one of the aspects that the proposed amendments seeks to change. Next slide, please. So last week, an amendment to the salary disclosure law was introduced to the New York City Council to make further revisions to this new law. And per the normal legislative process, the proposed amendment has been referred to the City Council's Committee on Civil and Human Rights. And the committee will, it's been added to the committee's agenda for April 5th. So we'll have to wait to hear, how that goes and see what happens. But here, as you can see on the screen, the amendment would limit the scope of the requirement for remote work positions and would only require disclosure for positions that are required to be performed, at least in part, in New York City. So if you have a remote position that truly can be performed anywhere, this would not apply if the amendment passes. The amendment would also increase the employee threshold to determine, for determining whether the employer is covered to 15 or more employees. and it would postpone the effective date to November 1st, which would give us a little bit more time to work on coming into compliance and preparing a strategy. It would also exclude from coverage any general notices that the employer is hiring if it didn't have a reference to a specific position. So that's New York City, but I just wanted to make everyone aware, be on the lookout for potential laws coming from New York State. There is pending legislation that we're following there, so there may be pay transparency requirements at the state level coming soon, potentially. I know that was a lot of information, so given all of that information and details, I just want to quickly go through kind of what that means for employers and what you should be doing now. So as you can see, the different states and jurisdictions have made quite the patchwork of different laws for employers to navigate. And that trend seems to only be heating up, so it's only going to get worse for employers. So really what you should be doing at this point is evaluating and assessing your current practices and whether or not they comply with these new requirements. And a lot of employers are actually looking to implement a nationwide strategy, especially those that are in many of the states with these requirements. And when you're thinking about a nationwide approach, if you are, it's really important to understand your organization's goals. Right, so what is it that you're after? Is it just that you want to ease the administrative burden and maybe you'll be willing to disclose a little bit more information to decrease the administrative burden? Or is it that you only want to disclose the bare minimum? Or is it that because of the current job market, you're looking to do whatever it takes to attract more talent, and maybe you're including in your advertisements additional forms of compensation that the states in which you operate are not requiring you to include. So it's a lot to think about. The other kind of main topic is to consider conducting an internal audit of employee compensation to see if there are any pay disparities that need to be addressed before publishing the pay ranges. Right, at a minimum, what you should be doing is at least considering checking that none of your current employees are below the range of the position that you're posting. Obviously, that can cause internal issues. So that's just a few things to start thinking about. Your approach really depends on which states you operate in and your goals for how you want to proceed. With that, Kim, are there any other questions that we want to address before we move to the next topic?
Yeah, great. Thanks, Christy. So a few questions. So if a company just has one set hourly rate and doesn't have a range for their positions, like a lot of their positions have little to no discretion in the pay offered, what does the company do in that case?
Yeah. So for New York City, they would just post the range. So for example, if position A, you have a set range and there's no kind of discretion there, or not set range, a set rate. Right. Say it's $50 an hour. You would just post on your posting $50 an hour.
Okay. And now what if there's a very large range? Is there a limit? Is there any kind of limit on how large the salary range can be?
No, so there isn't, as long as it's reasonable and it's what you in good faith believe that you would pay. So for example, you can't say for my accountant position, I'm going to pay anywhere from $0 to $50 million. Obviously, that's not reasonable. But as long as the range is reasonable, then you shouldn't receive any questions on having a large range.
Okay, great. And do we know in terms of the amendment, like the status of it, would it change the effective date to November?
Yes, yeah. So on April 5th, there will be a hearing on it. So we'll know kind of at least a little bit more at that point, whether or not we think it's going to move forward. And if it does move forward, the effective date would be November 1st of this year. So it will give us a little bit more time to comply.
Okay, great. Now, one last question, and then we're going to move on to the next topic, but additional questions can definitely be addressed in the breakout room. But one last question is, if you do have a set range, can an employer end up hiring someone outside of that range if the candidate has like extra, qualifications or skills, at what point are you sort of required to change that range, or is there a problem if you do end up hiring outside of that range?
Yeah, so it's not a problem if you're outside of that range, but if you are following the law and posting the range that you good faith believe that you are going to pay for the position, it shouldn't happen all that often that you're paying above the range, especially because you're permitted to make the range large. But in the example I gave, if you have this stellar candidate, you never thought you'd get a CEO or CFO level employee to apply, or applicant to apply for an accountant position, and they're willing to accept, a little bit more than the range that you posted, but a lot less than you ever would have thought you could gotten them for, you would be permitted to pay them above the range in order to hire them. It's really a good faith standard at the time of posting. So if at the time of posting you said, I never thought I would get that type of a candidate with that qualifications, then it would be justified that you would pay them above that range.
Okay. Okay, great. Thank you. So in the interest of time, we're going to actually move on to introduce Lotus to talk about the legal trends in website accessibility.
Hi, everyone. Today we'll be discussing legal trends in website accessibility under ADA Title III. Next slide. So just some background on the ADA. The Americans with Disabilities Act is a federal civil rights law that prohibits discrimination against individuals with disabilities. It covers these 5 key areas here, but today's focus will be on Title III, which applies to public accommodations. Next slide, please. So what is a public accommodation? It's a private business that is generally open to the public, and that falls within at least one of the following 12 categories. I'm not going to go through every one of, on this laundry list here, but just by briefly reviewing, you can see that it applies to hotels, restaurants, gyms, retail stores, colleges, etc. Basically, any private business that serves the public and is generally open to the public. You may notice that websites, which we will be discussing today, are not explicitly on this list, and we will discuss that a little bit more soon. Next slide, please. So under Title III of the ADA, public accommodations must provide equal access to their goods, services, and facilities to individuals with disabilities. And how you do that is by doing these 3 things. The first is to have and maintain facilities that are accessible. So an example of this would be if you're a cafe that has a stepped entrance and someone in a wheelchair wouldn't be able to use that entrance, it's important that you also provide an accessible entrance or a ramp that that individual would be able to use. The second is you need to make reasonable modifications to your policies, practices, and procedures when necessary. An example of this would be if you're an establishment that typically doesn't allow animals into your facility, that you make an exception for service animals. And lastly, you need to ensure effective communication with individuals with disabilities by providing them with auxiliary aids and services at no additional charge. An example of this would be if you're a restaurant and someone comes in who is blind or visually impaired and has trouble reading your menu, you should have an employee who can read the menu options out loud to them. Title III of the ADA is enforced by the Justice Department and specifically the Civil Rights Division. And below you can see what remedies are available under Title III. In the case of DOJ enforcement action, which you definitely do not want to happen to you, you can be responsible for very large penalties that are listed here, and the penalties are for each violation. So this can get very costly. In addition to injunctive relief, so basically remedying the violation and making sure that it doesn't happen again, and damages. In the event of a lawsuit brought by a private party, you can be responsible for injunctive relief and attorney's fees and costs. Now, under Title III, it doesn't provide for monetary damages in private lawsuits. So plaintiffs usually add on claims under state laws that do provide for monetary damages. Next slide, please. Are websites places of public accommodation? This is a question that doesn't have a very clear answer. The ADA does not specifically identify websites as places of public accommodation. If you can recall from a couple slides ago, they were not on in any of those 12 categories explicitly listed. However, the Justice Department that enforces the ADA has consistently interpreted the ADA to apply to websites of public accommodation, but they have not issued regulations reflecting this or what this means for businesses. And then to add to all this complication, courts are very split on whether Title III should apply to web-only businesses or if they should only apply to websites of public accommodations that have a physical location. So courts in the 9th and the 3rd circuits generally find that you need to have a nexus to an actual physical location, right? So for example, if you're a grocery store and then you have your website where clients can also place orders online, you would have a nexus to a physical location. Whereas maybe if you're like a Netflix and you only operate online and you don't really have a physical location that directly serves customers, you would be considered a web-only business, and in one of these circuits, your website may not be covered. Whereas courts in the First Circuit generally find that you don't need a nexus to a physical location. Next slide. What is an accessible website? Essentially, this is a website that can be used by people with various types of disabilities that are covered on this slide. The vast majority of lawsuits that we see in this area are brought by people who are blind or visually impaired who have trouble using a website with their screen readers because it's not coded properly. So this can create issues such as lack of alternative text for images, improperly labeled form fields, and this can be, a very frustrating and confusing experience for someone with a visual impairment. We do see a smaller number of lawsuits brought by individuals who are deaf or hard of hearing for lack of captioning on audio content. Next slide, please. Okay, so since there is no regulation setting out how a website needs to be coded in order to be considered accessible, we refer to these Web Content Accessibility Guidelines, or WCAG, that were developed by a group of experts. And basically these define how to make web content more accessible to people with disabilities. And these are constantly being developed and updated as our technology advances. And they've been updated over the past 20 years. And they continue to be updated. So we like to look towards, where the law is trending, what is the current generally recognized standard for accessibility now. And while this isn't a legal standard under Title III of the ADA, it has become the benchmark and the de facto standard for accessibility. So these guidelines are what courts will generally use, what any expert in the field will use when determining whether a website is accessible. Next slide. So why should you care about website accessibility? Apart from just doing the right thing, it is a very trendy lawsuit, as you can see here from this chart. Our ADA Title III team has been diligently tracking these lawsuits since 2017. And since 2017, over the past 5 years, these lawsuits have more than tripled and continue to be on the rise. And you can see there has been a 14% increase since 2020. So with the lack of guidance and the lack of clear regulations and consensus amongst courts, we don't see this number slowing down anytime soon. Next slide, please. So here you can see a breakdown month by month of these types of lawsuits that were filed in 2021. Also, these numbers do not include cases filed in state court, as well as the voluminous amount of demand letters that are sent for website accessibility. As you can see, the numbers stayed fairly consistent over the year, and then there was a sharp spike in November. This was actually the result of largely one New York plaintiff's firm that filed, I think, about 357 lawsuits in this month. Next slide, please. Okay, and these are the top 10 states with these types of lawsuits that were filed in 2021. These frontrunners here, New York, California, and Florida, tend to be the hotbeds of accessibility litigation and website accessibility litigation. If you're wondering why New York has so many more lawsuits in comparison to California, it's because the law in this area is generally more favorable for plaintiffs. Next slide, please. Okay. So now we'll talk a little bit about how Title III has been enforced under the current administration. We have seen much more vigorous enforcement in this area, especially relative to the previous administration, where efforts in this area effectively came to a screeching halt. So since then, and Kristen Clark currently heads the Civil Rights Division, and as we discussed, the Civil Rights Division of the Justice Department enforces Title III. And Kristen Clark has an extensive background in civil rights. As expected, we've seen much greater enforcement, and this is reflected in recent DOJ settlements, reflecting much greater remedies, compliance with stricter standards for accessibility, as well as statements of interest that have been filed by the DOJ in private actions in support of ADA plaintiffs. What we haven't seen, unfortunately, are new regulations and helpful guidance that has helped define the boundaries of the application of Title III to websites, or providing effective guidance to websites on exactly what they need to do to comply. So that still remains to be seen. Next slide. So on February 28th, 2022, 181 advocacy groups wrote a letter to Kristen Clark that was asking the administration to adopt enforceable online accessibility standards by the end of the current administration. So this just shows that the administration is under increased pressure to come out with guidelines, come out with standards, and this is a very important issue currently. Next slide. So perhaps in response to this letter and in response to this increased pressure, just recently on March 18th, the DOJ did come out with web accessibility guidance. This did state that the DOJ considers website accessibility a priority, and it listed some settlements that are helpful to see what the DOJ finds necessary for businesses to do to comply. However, this guidance didn't really provide any new legal insights or any detailed guidance for businesses beyond what we already knew. They did acknowledge that there's no regulation setting detailed standards, and the guidance also stated that businesses have flexibility in how they comply with the ADA, but they didn't really define what that flexibility means. Next slide, please. Okay, these are the three themes that we see litigated in this area. The first we discussed a bit before, and that's the physical nexus issue. So federal courts are still largely split on whether Title III should apply to web-only businesses, or if they should only apply to websites of public accommodations that have a physical location. The next is mootness. A claim is moot where you can show the court that you've fixed the problem and that the problem is unlikely to happen again. This can be tricky to accomplish with websites because they're so complicated. There can be so many issues and they're dynamic and constantly changing. But winning on a mootness argument is possible if you have a reputable expert who can certify that your website is accessible and you have a program in place to maintain that accessibility going forward. It is possible to moot a claim on this basis. And the final one is standing. A case will only be dismissed for lack of standing in a very narrow instance where the plaintiff could never use the goods or services that are being provided by the website. So an example of this might be that if your website only provides goods or services to individuals who are members of a certain organization or residents of a certain state, and the plaintiff wouldn't be eligible to use those services anyway, then it is possible that the case will be dismissed for lack of standing. I also want to note that in these second two issues, mootness and standing, there is also a lot of controversy amongst courts, and the determinations are highly fact dependent and court dependent, just like the physical nexus issue. And only a handful of cases have been litigated to judgment. Often these types of cases end up settling because the cost of defending these lawsuits are just so much greater than just settling. If you end up defending this type of lawsuit, you should expect to pay, in addition to your own legal fees, the other side's legal fees, damages, and the cost of remediation. And because typically there is some issue with the website, you will have to remediate your website anyway. So it usually makes a good business sense to just try to settle it early and try to take, whatever necessary steps to get your website into compliance as soon as possible. Next slide. So these are just some takeaway tips for avoiding and defending website litigation. The first is to obviously make sure that your website is accessible and that you have a program in place to maintain accessibility. A first step could be to just check with whoever is responsible for your website, whether that's your IT vendor, and ensure that you are complying with the generally recognized standards. You may also want to hire an accessibility consultant. And what they will do is do an audit of your website. They might have someone try to use your website using a screen reader. There are also automated tools that can scan your website for issues. They can flag any issues for you and then help you remediate those. You also would want to have a 24/7 telephone line so that if someone has trouble accessing information or using your website, they can call this line for help, and this will be an alternative means of providing effective communication. You want to have an accessibility statement, policy, and procedure in place. You want to train your employees, both the employees that are responsible for coding and maintaining the website, as well as your customer service representatives for how to provide equal access to individuals with disabilities. And finally, take care with your vendor contracts and third-party content to make sure that that content is also accessible. All right, next slide. Okay, and these are just some additional resources for you to check out. We have a blog where we write about any recent developments in this area, and you can find useful information on there. You should also feel free to reach out to me or anyone on the ADA Title III team with further questions.
Great, thanks so much, Lotus. So surprisingly, no questions came in on the chat box, but many of you out there may not know if your website is accessible or complies with the law. Definitely feel free to join Lotus in the breakout room where you can ask her directly any detailed questions that you may have. or even if it's just general guidance and next steps. So thanks, Lotus. And with that, I'm going to turn it over to Michelle for our last segment.
Thanks, Kim. So in recent years, New York has really been strengthening its protections for victims of sexual harassment. And we saw this last May when the Senate passed a suite of bills that were, again, to provide greater protection for these victims. They ended up dying in the Assembly last year, but they came back this year. 3 have become law, and 4 are still awaiting passage by the Assembly. So I'm going to start now by talking about the 3 that just this month were signed into law. Next slide, please. The first law will create a workplace sexual harassment hotline. So this is going to be a toll-free hotline where employees with complaints of sexual harassment can get advice and counsel from from attorneys on their complaints. And this is going to be operated by the Division of Human Rights. They are going to work with organizations representing attorneys such as the New York State Bar Association to help recruit attorneys experienced in these matters to be able to properly advise these employees. What we need to know about this law is that it does state that employers will need to include information about this hotline within any poster or other material distributed to employees regarding sexual harassment. So as it stands right now, we don't have any details on this, but the law does state that the division will be working with the Department of Labor to come up with such notice requirements. So we are going to certainly be keeping an eye out for any guidance from the Department of Labor. Keep in mind that although this did become law on March 16th when it was signed by Governor Hochul, it does not go into effect until mid-July. So we do have some time. And I think we just want to put this on your radar, and let's wait and see exactly what the regulations say we need to do to our current policies and practices. The second law will it is already in effect, and it prohibits employers from releasing an employee's personnel file in retaliation for an employee's complaints regarding any unlawful discriminatory practice or the employee's assistance in any related proceeding. So practically where this is come into play is when speaking to the media, we should be careful about what we are sharing. We should refrain for the time being from sharing any disparaging information or information about the employee that's meant to discredit their claim. The law does not define personnel file. It does not define what constitutes a disclosure. And so until we do get that further guidance on exactly what is permitted and prohibited, better to err on the side of caution. Do note, though, that employers may still release personnel files in a legal proceeding or as part of the employer's commencement of or response to a complaint. And the third law extends the human rights law to all public employers, including elected officials and judges' personal staff. Next slide, please. So while those 3 bills did in fact become law, we have 4 that were passed by the Senate, but have yet to receive any action from the Assembly. It's unclear whether these will pass or not. Again, they died in the Assembly last year, but given the fact that the Assembly did sign those other 3 laws that were part of this suite of legislation, it is likely that these will also ultimately become law. Next slide, please. So the first one, the Let Survivors Speak Act, if that is signed into law, it will go into effect immediately. And what it will do is prohibit any clause in a settlement agreement that will require an employee to pay liquidated damages or otherwise forfeit consideration if the employee breaches any non-disclosure or non-disparagement agreement that is part of the settlement agreement. So if this does end up becoming law, it will apply to agreements entered into from the effective date, which will be the date it becomes law, forward. So no need to worry about any existing settlement agreements, but we will want to revise our current templates to remove any of these liquidated damages clauses should this become law. We also cannot require any admission or disclosure by the employee that they were not in fact subject to unlawful discrimination. So that's something to bear in mind as well. The second bill would go into effect 60 days after becoming law, and it would also apply to agreements entered into from that point onwards, so not retroactive. And this would render unenforceable any agreement that is conditioned upon, it'll render unenforceable any ban on an employee seeking reemployment from that employer or related entity. So it's interesting to note, though, that while the effect of having such a no rehire clause in a settlement agreement will be the release of the claim will be unenforceable, but the rest of the agreement will stand, which means that the employer will still have to pay out to the employee with basically nothing in exchange because the release will be invalid. So that's something to bear in mind. Again, nothing to be done right now, but if this does become law, 60 days later, we will want to remove these clauses from our settlement agreements. The final two bills would extend the time period during which complaints and lawsuits can be brought. So the first one is going to move from 1 year to 3, the statute of limitations for complaints filed with the New York State Division of Human Rights, alleging unlawful discriminatory practices. I will note that it is already 3 years for complaints of sexual harassment. The second bill would extend from 3 years to 6 the statute of limitations for employment discrimination lawsuits brought under the human rights law. So I think what we see from all of these bills and laws is that New York is really trying to strengthen protections for employees. And this reminds us that we really want to be on top of our game when it comes to sexual harassment training and enforcing these policies to really eradicate any type of unlawful discriminatory practice from the workplace. With that, I'm going to open up the floor to any questions we may have.
Great, thanks, Michelle. What are your thoughts like on the likelihood of passage of these bills?
Thanks, Kim. Yes, so that is something that we've all been wondering. It is unclear at this point. As I mentioned, all of these bills were introduced last year. They died in the assembly. They came back again this year. It's interesting to note that 3 of them were passed on the assembly, while the remaining 4 were not acted on. They were all signed by the Senate on March 1st and delivered to the assembly at the same time. So it's possible there won't be any action on it this year, given the fact that the assembly chose to act on the other 3 that were part of this suite of legislation and not the latter 4. But I think we'll just have to wait and see what happens.
Okay, thanks. And then also, you know, one of the new laws that you spoke about that did pass, the protection from unlawful retaliation with regard to an employee's personnel file, did the law specifically speak to an employee's personnel file? And is there any reason why, you know, I guess that's brought into attention versus, you know, just in general, the release of negative information about an individual, like, you know, that it specifically is speaking about personnel file information?
It's interesting. So yeah, the law does specifically mention personnel file, and again, doesn't really define that term. There is speculation out there that this law was inspired by Attorney General Letitia James's investigative report into the allegations regarding Governor Cuomo. And it seems that several of his accusers mentioned how he had threaten to release their personnel files. And so I think the timing of this is interesting. And the theory is that this legislation was inspired by that and kind of trying to cut back on using these personnel files as a way to discredit or disparage these victims.
That's very interesting. Now, with regard to one of the bills that hasn't yet passed, on no rehire clauses. I know that this is a big thing for a lot of employers because a lot of times when you're paying out, a big settlement, employers like to have those no rehire clauses in there. What if the former employee had, such serious performance issues or, real policy violations? Is there any kind of wiggle room to continue to include the no rehire clause in there? Like in the bill, were there any sort of carve outs or exceptions?
So the bill is pretty broad, provides pretty broad protection for employees. And it does not seem like there is any such carve out. It seems like anytime there's going to be a settlement agreement between an employer and an employer independent contractor, a no rehire ban cannot be a part of that. Now that I want to clarify that termination of employment can still be part of that settlement agreement. So certainly due to policy violations, et cetera, the employee can be terminated. And this is not to necessarily say that the employer must rehire such an employee who comes back and applies again. However, the employer is going to be prohibited from barring that employee from seeking reemployment from the employer or a related entity. And again, I just want to reiterate that if this does become law, if a no rehire ban is in there, that will render the release invalid. But again, the employer will still have to pay any part of the settlement agreement.
Wow. So the employer will have lost its consideration. If they include a no rehire in, they'll still have to pay, but they won't get the release, is what you're saying, right? So,
Right.
and I assume if these bills become laws, at some point we'll see some guidance, hopefully, governing the broadness of the no rehire clauses, right?
Certainly, yes. The bills are quite short, and so I'm certain that we will see further guidance kind of illuminating what can and can't be done.
Right. Okay, great. Thank you so much. Wait, actually, let's see. One more question just came in. Right. So this is the tricky issue. So the question is that what is there to prevent an employee who signs a release and comes back to apply for a job and is not rehired from then filing a retaliation claim?
So unfortunately for employers, it seems like there is nothing preventing such an employee from doing that. I think the idea of the bill is that in a world where mergers and acquisitions are taking place daily and employers are becoming more and more related to each other, these no rehire bans can be kind of fatal for the careers of some of these employees who end up signing them in a desperate desire to settle. And so certainly this is very employee friendly. And yeah, I think it's just if that employee comes back and applies again, the employer should be sure to have on the record exactly why that employee was not hired.
Right. Thank you. I did want to announce this CLE code. It is SS as in Seyfarth Shaw 8302. Again, SS 8302. Or 02. And thank you to everyone for participating and joining us. And then please feel free to join us in one of our breakout rooms. Thanks.